Lordship, I would like to mention item number 7. Lordship, may kindly take up this matter after a week. I've taken the consent of the petition.
Yes.
Obliged.
Lordship, I would like to mention for the matter of Deru Jongloju versus State of Arunachal Pradesh and another. WPC number 146 by 2023.
For what listing?
WPC, Lordship.
No, do you understand? But for what? You are making a mention of that case for
Lordship, may the matter be listed for tomorrow.
tomorrow hearing or admission?
Hearing, Lordship, because Lordship, since it's been 2 months, Lordship, the matter has not been listed up. So
It will be listed next week. Since 2 months not listed, it will be listed next week. We'll provide next week.
next.
Give a date next week. Mention them. You'll have to give a mention memo next week.
Thank you, Lordship.
Yes, Talat, tell us what was the ITB 29th?
Intimation to the bidder.
No, not saying the date.
Which date?
Relating to the present process.
Okay.
First NIT or second NIT? Because two NIT was
Two NIT. First NIT was issued on when?
2/9, my lord, 22. 2/9/22.
2/9/22.
Yes,
And that was cancelled.
that was cancelled.
A writ petition was filed against that.
Against second NIT, my lord, writ petition was filed,
Okay, then.
which is something, my lord, then
My lord, first NIT was plotted.
Ah.
My lord, inserting the clause first class magistrate.
Ah.
Then after finding, my lord, that this is not in connection with the that Enterprises Act 2000, my lord, then that was cancelled.
Hmm.
Then, my lord, second NIT was plotted.
And what is the clause in the second NIT? No correction.
My lord, second NIT, my lord, first class magistrate was not required.
Not required.
Not required.
And now they participated.
Right from the beginning, my lord, he never objected. my
No.
lord.
We'll come to that argument. Let us understand the facts first. We'll go to the argument later on. So now, one, not two.
Yes.
Then there subsequently that was withdrawn.
Yes.
Then second tender was
Plotted.
issued.
Yes.
Where is that?
My lord, that is
page 51
of the 51 of the my lord rejected, my lord.
2nd September 2020.
Page 51.
Yes, this is the NIT.
Second.
Yes, second NIT.
Now here also you say that this is a first class.
My lord, no, that is first NIT is not problem, but any reason prior to this, there was first NIT. It was cancelled because of technical reason, my lord.
But it was cancelled because of technical reason.
Yes, my lord.
Then-
But that was not subject matter of challenge by any party, my lord.
Okay.
Now, this is my lord, this is subsequent, this is starting from. here.
Now about this, the earlier repetition and other litigation relates to this NIT.
Yes, yes.
29.
This one put
Now
it
you take a stand on
No,
affidavit
I'm
that
sorry,
1 and 2.
I'm sorry, man. This was not put together. This pursuant to this NIT, the 51 as referred to, this was processed, my lord, and then the technical bid was opened, wherein 3% only found responsive. Rest 13 they were not qualified.
No,
Then, my lord, then what happened on this ground, my lord? This NIT was cancelled and third NIT was plotted, my lord.
Come to the present NIT under which this and what
Now third NIT was, my lord, put to challenge by the one of the bidder, my lord, MS Don, my lord, in which this third NIT was quashed.
you first said there are only 2 NITs. Now you are coming to the third NIT. That's why specifically I have put this question. Which is the NIT under which the present petitioner participated.
My lord, this is 2/9/2022.
29 page 51.
51, yes.
Now what was the earlier repetition? Challenging which NIT?
After cancellation of this NIT, my lord, third NIT was,
So if after cancellation
my
of
lord
this
will kindly come to
NIT,
page.
how can he participate?
My lord, kindly come to page 36 for a moment. The writ petition which they are referring to, the paragraph 10, I have made the awardment.
my lord.
From here, my lord can
No, no, we
separate the
have
chair
seen the
from the
affidavit.
grace.
There is no problem on that. We have marked the affidavit also. There is
Correct.
no issue. Kindly tell us the history of this case, how the earlier repetition came to be filed. On your whole case is the affidavit sworn in by the government.
Correct, madam.
That this is their stand. Now they cannot change their.
They cannot reside.
This is your stand. So therefore, under what background that repetition was filed? In which they file an affidavit and said that this is our mistake.
That is, my lord, will get clarity from page 36. I have quoted the writ petition.
My
415, my lord,
Page 36.
page 36, 415.
Okay. You take your step. You argue your case.
Yes. My lord, the
Give us the
petitioner.
facts first. We'll come to the law later. Let us understand the facts.
My lord, page 21 onwards it starts.
Hmm.
If I have to take my lord to the facts first.
You narrate the facts already.
Yes.
Then if there's a requirement, we'll go to the documents.
Yes, my lord.
Just tell us the history,
history.
how it was issued, for what purpose, how it was cancelled, and how it was reissued.
My lord, earlier writ petition.
See, because
Earlier
they say, sometimes they say 2 tenders, sometimes they say 3 tenders. So you just narrate
No,
the history.
take your seat.
My lord,
Or narrate the history.
the first 2 writ petition, I am not concerned. I was not.
No, we are concerned.
No, my lord.
That's why we are asking.
No, my lord, that's why I am.
How? Because the work is same. There may be 3 NIT, and otherwise we would not have been concerned, because it is your whole case that affidavit they have taken a stand that this was our mistake. If that is their mistake, let them correct their mistake. Can they take a separate stand now?
No.
So therefore, you tell us the facts.
That's why, my lord, the first, this 415 writ petition, that the whole case, my lord, will see at page 322. No, 322. 342. Sorry, my lord, the paging 342. 342. 342. Annexure 5. I think we made a wrong. This is Dawn Enterprises.
Just a minute.
This is- And here the third call NIT was put into challenge. Page 342, my lord.
342.
Yes. Para 2, my lord, I read. 344. The order starts at 344.
29. So there was a direction to take a decision on 29/2022. Okay,
Correct.
the cancellation.
Cancellation. Where I was not part of the read proceedings.
So first NIT, first or second whatsoever was dated 29/10,
2910.
2022.
29 is third call.
Hmm?
After cancelling NIT dated 2nd September 2020.
Page 350, my lord, will find that statement.
29/10 was silenced in WPC
WPC number 415.
415.
415. Okay.
What about this direction? 415.
415. my lord,
You have
was-
not taken any decision. You just plotted a third tender.
No, my lord.
Cut. My lord, that 29 NIT, my lord, wherein my lord, the don't enterprise the challenge, and there is a direction from the Honorable Court, my lord, to finalize the tender process, to take a final call, my lord. So accordingly, my lord, we opened the technical bid. Out of 16, my lord, 3 qualified. 13, my lord, they disqualified because of that reason, my lord, point 2.0,
So you
my lord.
have opened the NIT pursuant to order
That-
dated 30
yes.
to 2020.
Exactly. Yes, my lord.
According to you, but first NIT was 29.
No, 15 July 2022. There's was some technical reason, my lord. Officially, that was cancelled,
That
my
was
lord.
not been objected.
Nobody-
Any
No, no,
other
okay,
Yes,
fine,
so
that has gone.
That is gone.
Then you
Then-
issued NIT dated
29.
29
Yes.
2023
23.
and subsequently without cancelling you have issued another NIT of
No. That was cancelled, my lord. Because of that cancellation, fresh NIT was plotted.
First penalty was brought in on 29/10/2022.
Yes. Absolutely.
Now 29/22 was challenged on the ground that 29 without cancelling 29 you have issued the 29.
That is wrong, my lord. That
No,
was
wrong or right?
Yeah.
Why you are arguing? Let us understand the fact. This was the fact. Is it not? It is right or wrong will come later at a later stage. It is a fact that 29/10/2020 was challenged on the ground that 29/2020 was not cancelled and this tender was issued. Is it correct?
My lord.
Correct.
My lord,
Facts. Don't argue. Facts.
No.
Is it correct?
my lord, substantially, yes, my lord.
Challenge is a fact.
Challenge was, my lord, because they have already submitted all the base document without bringing into, my lord. That was, my lord. Not because, my lord, we have not cancelled, my lord.
The order dated 13 to 2023 specifically says
My lord.
that this petition is directed against the NIT dated 29/10/2022 issued by the executive engineer.
Yes,
For
my
what
lord.
reason? That 29/2000 has been issued without cancelling that. This is a recorded fact in a writ petition.
Yes, 344. That is.
Any
lord.
dispute on that?
No dispute. my lord.
Okay.
That 350 is clear.
Okay, if I have understood the facts.
Well-
Now, this court says, yes, you have committed a wrong. So go to 29. Is not it? Whether this order is under challenge.
No,
Anywhere.
ma'am.
No.
No.
So now you will have to open the tender pursuant to NIT dated 29/2022.
Yes.
Is it correct?
Correct, my lord.
Now 29/22 you will have to open. Now what is the tender clause in the 29/2022?
My lord is a first class magistrate, my lord.
First class magistrate.
Yes, my lord.
What was the clause in the 29/10?
That was omitted.
Huh?
That was omitted, my lord.
That condition was omitted.
That first class magistrate condition was omitted, my lord.
Omitted.
Yes.
Now you say, why have you omitted? You say on affidavit, why have you omitted?
My lord.
While
My lord, we have.
please
Yes.
listen to us. If we have done anything wrong in this process, we'll hear it. So court holds that yes, you have committed a mistake by issuing 29/10. Therefore, go back to 29 by the learned single judge that is not under challenge, that has attained finality.
Right.
Now you not only finality, you acted upon that order. Now you go to the 29/2022, right? In this read proceeding where 22/10
Yes,
was challenged, you take a specific stand that we have committed a mistake in the earlier clause saying that this should be a first class magistrate first class, but it should be a magistrate because the act says itself. If that being the position on record, how can you interpret it differently? As simple as that.
Mana,
I think that is the case.
no,
That is the case.
but there is a direction from the court to make a final call to that NIT, my lord.
To the,
Then we have called that a final NIT, my
you
lord.
have done it.
Yes, my lord,
You
we
have
have done
done
it.
it. There is a direction to make a final
Yes,
call.
yes.
Final call will not make that your decision in the tender process cannot be challenged in any proceeding.
But then what about the other 3% who have qualified, my lord?
They are qualified, you have not opened the private, you
No,
have
no,
not.
we have opened all the 16 bidders, my lord, with documents,
No,
as
you
per
have,
directives.
you have opened the bidders, it's two bid system.
Yes, my
Or
lord,
single bid.
Two
it's two bit
It's
system
technical.
and
you have-
finance.
Both you have opened already.
Yes,
So you take their case price bid also.
my lord, that will be, my lord, amending the terms and condition of
No,
the
no,
NIT.
so we will answer this.
My lord. My lord, my simple understanding, my lord, as per the directive of the Honorable Court, my lord, we comply with that.
Yes, you
My
have
lord,
complied.
basic, your
But
lord,
will
But-
it give you a unbridled right to act in the manner whether you want?
my lord,
This court has given that no, you cannot say, you cannot do it or you cannot.
then my lord, the Honorable under single judge ought not to have quashed that NIT. They could have said something else, my lord. Because our pleaded case was that, my lord, because of that inadvertent instance of first class magistrate, which is not in concern with that district based enterprise, that was not accepted by the under single judge, my lord. That was the reason for cancellation, my lord. That was not accepted, my
Show
lord.
us that-
Otherwise, my lord, it
show
would
us
have-
that affidavit. Is it a part of the?
yes, yes,
Yeah, my lord,
yes,
kindly come to page 36.
it's a part of AP.
No, that is,
I have-
we are not on the pleading.
No, no, my lord, I have just exerted all the paragraphs.
That contention, my lord, we cannot deny. Once it's a part of the record, my lord. Your lordship will find, my lord.
Let
Start
us see
from
the, let us see the judgment of the learned single.
Page
In the
343, my lord.
344, na?
343, my lord. Start from 343, operative portion, my lord. That will be.
Huh?
Your lordship may kindly take note of paragraph 19, my lord.
Just will come.
Sir, which page?
346,
346.
346. Of course, it start from 343, but operative, my lord, the relevant is 346. Then.
Three, four, six is not reproduced at paragraph 10, page 36 of my pleadings.
Paragraph 19 is clear, my lord. The 13 bidders, they have not submitted as per the terms and condition, my lord.
Now come to paragraph 12 of the judgment of the learned single judge. Page 349. In dealing with your earlier things.
Yes, ma'am.
So you are at liberty to interpret. Kindly come to once an NIT is issued by the authorities
My lord.
and the bid submitted person thereto, I am of the view that the respondent authorities are duty bound to take a decision in the matter, either rejecting or accepting the bid submitted with cogent reasons. It is so because the participant bidders who have submitted their respective bids pursuant to NIT so and so have the right to know as to what is the fate of bid submitted by them. So the reason is Since you have initiated, continued, bid submitted, open it. What is the necessity of giving? So the learned single judge not even entered into the merit whether it is to be interpreted or not.
That's why we have headed to the terms and condition of
So,
that NIT, my lord.
so therefore, you are given a liberty to continue your interpretation.
Yes, my lord. So,
Your interpretation stands.
so finally we have interpreted, my lord, in terms of the NIT, that it should be a first class magistrate.
And your stand on oath. Who
Mother-
filed this
But
affidavit?
that was not accepted by the Honorable Court, my
No,
lord.
this court has not even entered into that.
Well-
Court says simple that
Ah,
since
my lord,
since you have initiated and it's reached to this
With
stage,
utmost
therefore
respect, my lord.
you continue it.
But we do utmost respect, my lord. Otherwise, the Honorable Court ought not to have passed that NIT, my lord. That 29 NIT, Honorable Court cannot,
Now
ought
we are
not have to pass that, my lord.
understanding, we are finding it difficult to understand why the state is not interested in larger participation. We can understand the anxiety of the private respondents.
But the larger participant, my lord, you lordship may see the total numbers of my lord participants, 16, my lord.
Yes,
Unfortunately, out of 16, my lord, only 3 qualified.
that unfortunate things can be make it to your fortune of the state.
My lord,
Somebody offers five crores to complete and somebody says I will complete in 3 crores. State is not wanting to participate them in the tender process.
Mother-
Only on the technical ground, and which is also according to the state on affidavit that it was mistake on our part. See,
my
the
lord,
fallacy.
my lord, can we, the tendering authority, the author of the terms and condition can deviate from its own terms and condition, my lord? Can you do
No,
that,
you
my
can
lord?
deviate for the terms and conditions. As the learned single judge has rightly said, this is up to you.
Yes, my lord.
But in case of public interest, court can very well interfere with. The same judgment quoted, kindly come to Mandal,
Yeah,
Jagdish Mandal.
Jagdish Mandal.
Yes.
Yes, my lord.
So according to us, this is against public interest.
My lord,
The interpretation more so in view of the provisions of the act and rules
my
itself.
lord, same thing happened, my lord. Just like similar things. My lord, NG project. NG project, my lord, 13 bidders they have participated. Out of 13, my lord, only 2 qualified, my lord. They have accepted, my lord. Same proposition law. They have not
What is the ground of rejection?
here, my lord. They have not complied with the 0.20, my lord.
What is that?
Wherein it says, my lord, these are the documents you have to show before the first class magistrate.
It's an affidavit.
Yes, my lord.
He has submitted an affidavit by the
Executive magistrate.
Doesn't matter. Has the
But-
executive
But
doesn't
what,
have the power to execute it before the executive magistrate?
my lord, then
Your
what,
act says only
my
affidavit.
lord, then what about
Is
the,
it not empowered? It is only the JMFC.
my lord, then what about the terms and condition? Can we debit
What
from that, my
about the
lord?
rules?
Huh?
What about the rules?
My lord, basically we do respect, my lord. The terms and condition will be the guiding factors, my lord.
No,
My lord.
with due respect to your argument.
My lord. Otherwise,
The statute, it is action of the legislature.
Correct,
Huh?
correct.
So action of the legislature mandating to do certain things in a certain way, you are
Well,
bound to do this.
my lord,
That
legislature,
clause itself you have admitted that was a mistake on our part, on oath. What remains?
my lord, repeatedly. Then, my lord, the learned single judge ought not to have passed that, my lord, third NIT, my
Then
lord.
you could have filed an appeal.
My lord, has given liberty to, my lord, open the technical bit, my lord, to bring into logical
The
conclusion.
setting aside is for the reason, there is a setting aside, for the reason that the first tender process initiated, bid submitted, everything is over. So there should be a logical conclusion.
Yes, ma'am.
That's all.
Yes.
So while doing logical conclusion, even a handle has been given by the learned single judge to reject the tender with reason. And this reason is under challenge
My lord, we have given.
the learned single judge has said that there is substantive compliance, but our hands are tied because of the Jagadish Mandal and Tata Silva. We do not think so.
Yes,
That,
ma'am.
that read court's power should be curtailed to that extent in tender.
My lord.
And if we take your plea, then all time to come, a division bench passing an order saying that hands off your tender process, it's not the
No, my lord. My lord,
And we think.
Cannot be,
we
madam.
think
Cannot
serious
be.
public interest
If
involved.
there is madam gross violation, if there is a proper violation, yes, your lordship can
It's
interfere,
a,
madam.
it's a gross
Now, madam,
violation
now
because the
your
law
lordship
says
may kindly
something,
say.
you have done something.
My lord.
And you have admitted that this is our mistake.
My lord.
Clauses, nothing more than that. Thereafter, the rejection is absolute irrational.
Malad, my understanding goes, malad, substantive and complete is different, malad. Substantive, malad, maximum, up to great extent he has complied with, not complete, malad. That's makes it different, malad. We want complete compliance of the terms and conditions. That will only happen once he make a affidavit before the first class magistrate. My lord, now, my lord, our understanding.
According to you, the terms requires that its affidavit should be from the first class magistrate.
Yes, my lord.
Why?
My lord,
When it doesn't say under the act or the rules.
no, it doesn't say. But as mana category of judgment laid down, mana right from Judicial Mandal, then mana they are the master of the author. They are the author, mana.
According to us, when
Because-
when the tendering authority says that, see, this is the rule.
Well,
If this rule says it is a magistrate, but by mistake we have said it. Please
Yes.
listen. But by mistake we have said it to be judicial magistrate. That was mistake on our part.
then
That was a mistake on our part.
yes,
And therefore, we wanted to correct that mistake. If you wanted to correct that mistake, interpret that mistake in that way. And when these three things are available, the rule says a magistrate, your stand is that it should be a magistrate, and you cancel it on the ground that it should be a judicial magistrate, then it is nothing but irrational. And when it is irrational, Jagadish Mandal says it should be.
there is slight different, my lord. In that act, my lord, it says only affidavit. Does not say anything about the magistrate, first class, second class, third class, my lord.
So affidavit is always before the magistrate or notary. Who can administer a note? What is the meaning of affidavit?
Section 3 and 7 of the affidavit.
Affidavit means it should be a declaration on oath.
Yes, declaration of
Oh,
confirmation
oh.
by any person before a competent authority.
Competent authority.
But as my friend says, my lord, oath, my lord, does not says, my lord, even here also, man, which document to be shown before whom, my lord? If my lord, if any can,
So
then
therefore,
who will decide, my lord?
Will be accepted.
Then, my lord, the question comes, my lord, who will decide, my lord, which affidavit should be shown before whom
No,
authority?
you can decide. No problem on that. When the decision is irrational, we are here to seek for to do the judicial review.
Then another aspect you lordship to see, my lord. My lord, asking for filing the affidavit or swearing before the first class. Is there any violation? Any fundamental right infringed to the petition or not?
No, here in a tender method, there is not coming to which a right. It's not a reasonable restriction because of your conduct.
But that condition applies to all, my lord. All the 16 bidders, not only to Mr. X and Y, my lord. So how there is violence, my lord?
Because
What right
then you will
is
get a
violated?
16 participation only on the ground. And what is the requirement? Two requirements. One, he'll have to declare that, see, I will complete the work within stipulated time. This is first declaration.
My lord.
Second declaration that, see, first declaration object is that government's interest is assured. Second declaration is that, see, I have not having more than 2 works as on date. According to us, object of such mandate of law is to have a distributive justice, because the tender itself is confined to a district,
My lord.
a domicile of a district. It's not that it is open for everybody. It is in the interest of the public, and it's in interest that there should be a distributive justice. One person should not have more than 2 works. With this equality object in the rules, can you reject on this ground?
My lord, when you say, my lord, the
That
SPD,
is called irrationality.
Yeah.
That is called Jagadish Mandal. Yes, you can do judicial review of event tender work if these
My lord-
things are irrational.
my lord, your lordship may kindly see the mother SPD. My lord, as per this point 2.0, my lord, para 11, what are the documents it says? There are 5 documents, my lord. Your lordship may kindly see the page 78, my lord. Is it so tough, my lord, that he cannot, my lord,
No,
make a sworn before, my
cannot
lord?
is not the issue. Issue is
My lord, the
that
condition,
whether that form is a fatal to
But-
the entire tender.
my lord, any of the terms and conditions restrain the appellant to my lord exercise that? Is it so impossible for him to my lord to execute that? That part also you lord have to see, my lord.
Possibility of impossibility. It is a part of a question whether your action in rejecting the technical bit of the petitioners in three backdrops. One is the rule. Second is your affidavit relating to the same NIT, that it is your mistake. So you interpret, and thereafter your interpretation in an absolute contra manner is whether rational or irrational. Then if it is rational, we'll say that our hands are off. We cannot interfere with your decision because you are the best judge to do this.
Yes.
You have judged it, and you have judged it in terms of the rule. Now you cannot turn around. According to us, this is irrational.
My lord, now my lord, putting this, my lord, this 5 condition.
And the second part is that according to us, this action on your part is against public interest and against the object of the act itself. Because you are discarding the persons who want to participate, more participants, and you are discouraging more participation.
My lord, my understanding is different, my lord. My lord, subject to your lordship correction. Now, my lord, overall public interest will be achieved. What, my lord, the education process is start? Because it's a time
Yes,
bound.
that will give
my
you
lord.
a specific
My lord.
time frame.
My lord. Now, my lord, time and tide will wait for none, my lord. It will not wait, my lord. You see, my lord, now, my lord, is a
All
working
these are
season.
your creations.
My lord, this
All these are your creations, time. Everything
My lord-
was there. You have just changed it. You could have interpreted
My lord-
in that way.
suppose for a moment, my lord, if I consider to your lordship view, my lord. Now, my lord, what will happen to those 3 persons, my lord, who have completed as per the
Who has
terms and
completed
conditions?
what?
My lord, they have complied with all the terms and conditions, my lord.
No, terms of condition as you define. They also fulfill the terms and conditions
No.
as till now we define.
Substantially, they have complied. My lord, as held by the, my lord, landed single judge, as contended by the appellant, substantially they have complied. Not completely, my lord. That's the makes the difference, my lord. To the great extent, they have complied with it.
That's why Potter is still.
For the same.
My lord.
Yes, my lord.
Then, my lord,
Ancillary and subsidiary.
then there will be a deviation. There will be deviation amendment of the terms and conditions of the NIT. That is my son. Can we do it, my lord?
According to you, that will mean by a judicial review changing the terms and condition which has already been interpreted by the tendering authority. That is not permissible under law. That is your argument. And that has been upheld by the learned single judge. Says that yes, everything is done, but we cannot do it as Jagadish Mandal has said. And other judgment has said that in tender condition, you are the best authority.
There's a rightly following through your lordship that single judge order has attended finality, my lord. Yes, my lord, we have complied to that, my lord.
Okay.
Yes,
Allowed. Order to
Grateful.
follow.
My lord, now, my lord,
Who are not
Same.
only him.
same on the ratio, my lord.
Same.
My lord, same on.
All.
My lord, same, my lord, ratio, my lord. That has been in my lord, NG project. Then subsequent
All
Tata, my lord.
deal with your arguments. Just we have to.
My lord, citation, my lord, you can give me lordship, my lord. My lord, under what circumstances, yes. Hands are not tight absolutely, my lord. Correct, my lord. When your lordship can find, but there is gross violation, yes, your lordship can entertain. But your lordship to see, my lord, the parameter of greater public interest, my lord. That's it.
And for convenience, my lord,
I-
I just compiled my line decision, my lord. My lord, I'll just apply with gist of point of law.
Okay. We'll get this order on Friday.
Well,
If so many judgments are there.
I-
We have to quote this judgment.
I think, my lord,
came back with my blue book.
Mal,
today.
I think NG project will comply everything, Mala. That will address everything, Mala.
Everything.
Yes, NG project.
I deal with intra-court appeal as well as, and also if there's the situation where there's a two possible
Interpretation.
In that case, the interpretation adopted by the
Author.
authority cannot be interfered with. That's part of
But not the act and rules.
We have 10 rules.
Correct.
The language, the terms which we have used in the
Yes.
tender,
In
the
your
best authority is the tendering authority.
My
That's
lord, may,
not act and the rule.
my lord may kindly note, Mala. Act and rule does not say, Mala, first class,
Do you-
second class. It only says
Don't
affidavit,
you
Mala.
have,
It only says affidavit.
In that way
Then-
we'll interpret.
Then who can interpret, Mala? It is the Mala author, Mala.
Oh, sorry to say, rules you will interpret and we'll sit over.
Because we want, what? We want from the bidders,
That is not permissible under
You
judicial
want,
review.
you want to have the unfettered discretion.
No, then who will give the clarification,
And don't you have the faith on your executive magistrate?
No, that is not the question, Mala. That is not the question, Mala.
It is you who,
Mala,
who
question,
has,
what do you want, Mala?
it is
What do
you
you
who
want?
has appointed them as an executive
The question is
magistrate.
not the faith, Mala. Then Mala, same question I can ask, Mala. Can we have a faith on Mala JMC, which is higher in grade, Mala? Same thing, Mala.
We'll pass
That's only
this.
one point
But
of
this is not only for, this will not mean to the only the petitioner. It will be for all the persons whose tender has
Correct,
been
correct,
rejected on this. Count.
correct.
It is not only for you.
I have put in one judgment rendered by Lordship, another judgment by Lordship Ate, on this.
Give us.
I have submitted my list of books.
Friday you will get it.
Yes.
And
Mala, just I clarify.
my lord, one more small supporting, just Shankar Ram case.
We will not hear you. When we want to hear you, you didn't say anything.
Only
You did
aspect,
direct facts of the matter also.
Product still, madam, although there was no judicial order, madam. In this case, madam, the tender has been processed pursuant to the direction of the single pay.
Suppose we say,
Now-
that you complete the tender process in terms of so you will interpret this. Now, will that mean that you can do anything or
Then, madam, the General Financial Rule 2017, madam, clause rules 173, madam. It says that it has to be evaluated, whatever condition you have, you cannot modify or alter, madam, at the time of evaluation. That is what we are binding by the rule also, and there's a direction, madam.
you have
That's
written
why-
all this?
That question is all dealt in Mala NG project, Mala.
Yes.
Entire thing. Only Mala, as per Act, Mala says affidavit. We have just clarified the affidavit is to be made for who. That's all. We have not tempered or deviated from the Act, Mala.
And
We
you
have
have also said that it should be a magistrate, not
But we have
first
only
class,
clarified.
on oath,
We have
in
only
a
clarified.
judicial proceeding before a high court.
Unfortunately, that was not accepted, Mala. That was the contention, Mala.
We are
That was not
division bench.
accepted,
We
Mala.
are sitting in a division bench.
Yes,
Mala,
that was
We
not
can deal
accepted.
with it. That is not binding upon us. We can interpret still.
Deeply applied.
Have the participation, whosoever gets.
My lord, this is a contempt petition, my lord. My lord, even after, my lord, more than a year, my lord. After the,
Yes. What is this? There is an IA, you file IA saying that applied, it was a consent order.
my lord. I've even, my lord, abdicated 50,000 rupees even, my lord.
There was a IA, disposal of IA, where you sought for time. I think there was extension. Extension was also over during the pendency of the IA, till date not. But
My lord, I am for the contempt number 6, Deputy Commissioner. My lord,
you have rejected.
no. Before I start,
No, nothing start. What you want to start? Who will comply when it will be complied?
no, my lord, what had happened? Pursuant to the sacrosanct judgment and order of this honorable court, the acquisition notification was issued, my lord. Thereafter, the Deputy Commissioner initiated the process of hearing to ascertain the rightful person whom the compensation should be given. Then finally, what had happened was, when summons hearing took place, my lord, then they could not substantiate it with the documents. Now there is another lady, the actual landowner, the chief mania. She submitted 2 LPCs. 2 LPCs, my lord. And in these 2 LPCs, their lands are there, my lord. Their lands are there. But the chief mania has not transferred the land, my lord. So in that view of the matter, the Deputy Commissioner prudently feels that instead of creating further mess in the case, because on the one hand, my lord, the Damocles sword is hanging on my head in the form of contempt petition, I have to comply with. So therefore, my lord, we have Deputy Commissioner has forwarded it to the Land Department, my lord, Secretary for further decision, my lord. It is not that, my lord, nor there is a willful or deliberate actions, my lord. Kindly come to this particular
Who filed this affidavit?
My lord, I am preparing for respondent number 3 and 5. In fact, my affidavit is ready, but I'm only waiting for one document first, annexure. I'll be filing it.
My lord will see, my lord, kindly, my lord.
See, contempt will have to send them to jail. If he wants to file an affidavit, let him file, then we'll send him to jail, because we'll have to give him a chance, then we'll have to draw the.
Contempt is
contempt.
between the court and the contemner, my lord. His duty is to bring it to the
No,
notice of the
that's,
court.
that's not the issue, but we want our orders to be complied with.
Correct, my lord.
As simple as that. And in here, this is a case where you have filed an application saying that please give us some time to comply with the order.
That is a state.
Okay,
I-
court says,
I think
okay,
so.
we are giving you time. During pendency, that petition also becomes the time prayed for is also elapsed.
That is there, Lordship. But the difficulty, Lordship, my concern currently explained, Lordship. After the order issued by this honorable court, where
Just remind yourself that we know how to get our orders complied. Don't take it to be an ego. We know how to deal with your orders like this. Be better be aware of.
My lord. Even in the read appeal, my lord, 50,000 was awarded as a compensation for high-headed.
Consent order. You admit their pleadings.
My lord.
On the basis of that, this has been done. Can a subsequent order be passed?
No, my lord. This,
Sitting over the orders of
My
this
lord,
court,
the deputy commissioner has no authority to go on the question of
Mr.
who is the
Tara-
owner, my lord.
be careful
my lord.
and ask your client to be more careful.
My lord.
Yes, when this is not accepted.
My lord, last chance fixed date may kindly be more than 1 year,
Yes,
my lord.
file affidavit. If they are not the owners, why have you issued notice to them by the magistrate that you will have to stop construction?
My lord.
If we start poking into this, you will be in difficulty.
They were in their
Ah,
possession.
ask your client not to be too smart. What has been decided by a reed court, affirmed by a division bench on consensus.
Yes,
I
On
bought on-
consensus.
I bought on.
And now you file an affidavit and say that this is wrong, this is, I am the authority to decide who is it. That has already been decided who is entitled.
yes, my
So better be careful.
Grateful.
This better be careful.
Lordship, here I'm for the.
We know how to handle with this kind of officers. Yes,
my lord,
Lordship, for I am 1 and 4, but then Lordship here, the last occasion also I pointed out many times, Lordship, post title may be changed, Lordship, because this requiring department 4, I am respondent number 4, Lordship.
yes, whatever correction is need to be made, file an application.
Yes, Lordship. Post title
Point
has to be
point
changed,
it out to
Lordship.
him.
That
He has been transferred in the month of June 2022 itself, Lordship. This
And
contempt
this
has
was
been
a
filed
case
in-
where you have absolutely, you acted like a monarch. Not like a civil servant.
I'll
working in a
advise,
republic.
I'll advise my client.
Better advice.
Yes.
Huh?
My lord, one thing, my lord. All the respondents, my lord, there is no any problem
And
from other
even
respondents.
we,
It's only
even-
respondent number
even-
6, my
Even we suppose we dismiss against other, be careful of your plan. This is not the way to deal with a single bench order then affirmed by division bench.
I agree.
We'll handle with it.
My lord, last chance, my lord. More than 1 year, my lord. It's going to be.
Yes,
Lordship, in the meantime, Lordship, post title may be changed.
He has to file the
Uh,
IA.
File appropriate application for implementing
for
the new incumbent. What's the problem? No problem. I had discussion with client, but from my client instruction is that.
They'll remain, but you also implement the new.
New also,
incumbents.
new also, but 4 will be there also because instructed by.
you do what.
Yes,
also
yes.
has
But
been changed.
we
We'll give you
change.
a week's time to complete the pleadings.
And respondent number 3 also has been transferred from order.
Oh, forget about that. The transfer will not mean that he is out of contempt.
Yes.
Even if he retires, he will not be out of contempt. If he is transferred, if we cannot take action against him, we'll see later on.
No, that I agree.
We'll say later on.
That
Here I have seen that they want to substitute. Where is the question of substitution? If contempt is done, it's done. And here double contempt. You have taken permission file application for extension. It's not your case that no, we are unable to do. It's a we cannot comply.
You have filed the IA.
I
Okay. Okay.
filed by the deputy commissioner.
Well, that factually I was not aware.
No, better be factually aware. You are in a contempt jurisdiction. We may call him tomorrow here.
I'll not, accordingly, I will advise my client, I'll call him to my chamber
this is
and
not a way to deal with the court's order. He will seek an extension, then he will pass an order. Who has asked him to pass order? Court has come to specific findings that they are entitled to give him compensation, and you have wrongfully, illegally evicted them, therefore cost of 50,000. In the division bench, you consider that okay, we will comply with the order, but please excuse
Yes.
us for this 50,000. The petitioner says, okay, we do not want that
understand it was
50,000.
my lord's order. I was not part of the.
No, may not be part
Yes,
of
but
it. The
I,
moment you have taken a brief, it is your responsibility. And we will not go by whatever you have advised or not advised. We'll go by the what the way he has conducted.
Well,
As simple as that.
I'll advise appropriately, calling
Yes.
him to my chamber.
This next week.
Yes, next.
Give a date.
Grateful.
But next
So as to enable contempt number
not more than a week.
to
Next
file
Thursday.
your affidavit, right?
Affidavit on behalf of
Even both of them will have to file.
3 and 5.
Lordship, I'll be for 1 and 4.
1 and 4. 3 and 5, 1 and 4. Thursday.
Grateful.
Yes, my lord. I have filed one IA, my lord, for implement as an appellant, my lord. The respondent, my lord.
Well, three, some time ago, we are filing a reply to this IAM.
Implement.
One way, at least 1 week.
But
It's almost ready, man.
Huh?
It's almost ready, man.
Okay. The learned counsel for the petitioner / opposite party submits that the affidavit in opposition is ready and same could be filed within a period of 5 days from today. Full stop. Accordingly, he seeks for an adjournment. Prayer is allowed. List accordingly.
Obliged.
Obliged.
My please, my lord. My lord, here parties have amicably settled the matter out of the court. Now, only things that in the impugn judgment order.
No, you do one thing. If you have amicably settled.
Yes, my lord.
We are in a first appeal. You file an application saying that this is the settlement.
Yes.
So dispose of this appeal on the basis of this. Then we'll pass a decree in terms of the compromise settlement. There's a provision in CPC.
Yes, ma'am.
Where you can compromise and file a joint application. Saying that a compromise decree be passed on the following
Yes, ma'am.
settlements.
Yes.
So accordingly, we'll be part of it and we'll pass it as a decree.
Yes, ma'am.
The learned counsel for the party submits that the parties have amicably settled their disputes and accordingly they are filing a joint application for passing of a compromise decree. Accordingly, they pray for a week's time or 10 days.
10 days, ma'am.
10 days, 2 weeks time. Prayer is allowed. List accordingly.
Most obliged. Deeply obliged.
My lord, I want to mention item 1 to 4.
Yes.
Yes, we could not swear in our this petition today because deponent could not reach from Coloriang. So I need some time.
There is an interim order.
In the last
Friday,
occasion,
Friday, up to Friday, if you can give, no, Friday we'll do this.
Friday difficult, next week.
Lordship, in that case, Lordship, list this matter after 2 weeks, Lordship. Then the interim order may be continued, Lordship. Because in the last occasion, your Lordship has called for the records,
We thought that this is a matter of public interest.
Lordship.
We will, it's a tender, isn't it?
Lordship.
And the case of the petition is only rejected on the ground of non-registration.
Lordship.
Now, apparently, you say that it is CPWD, not under the act.
Lordship.
But under the district act, it specifically said that registered anywhere, but it should be a domicile.
Lordship.
You are not saying that he is not a domicile. Isn't it?
My lord, last time your lordship has sought for a rejection order. Then,
Rejection order.
Lordship. And no rejection order has been issued to us also, Lordship.
We are
Only verbally, Lordship.
Huh?
we are filing petition on opposition. We'll give everything there.
Okay, let the matter call is item 1 only. We'll just wait.
Lordship.
First matter. Let the other matters be over. We'll
Lordship.
pass an order. We'll adjourn it. No problem.
Okay.
Yesterday I have filed writ petition with regard to transparent costing matter. Matter was yet today supposed to be listed to the not listed to the I am informed by the registry that there was a pending debit application. So I have served the copy and all. Matter will be listed today in the second half. There is urgency in the matter.
When the transporter was issued?
Recently,
Recently means date?
the partial notification order has been issued and
No. What is the urgency to know move and unlisted? We must know when the order was issued, when you have filed the writ petition.
yesterday I have filed.
You have filed yesterday.
Yesterday I have filed.
When the order was issued.
Order was issued on the 7/7. Not 7/7. Partial modification order is locked.
No, first transfer order was issued. Transfer order issued.
I'm not agreed with the first transfer order. I
Ah.
have joined
Ah.
before the this transfer place of posting.
When? When the first order was issued?
It was in October.
October.
Yes.
Then when have you joined it?
I have kindly see. Joined on 12th October.
12th October.
Yes.
And when the modification order issued?
Impugned order has been 7th of this month, 7 November 2023.
But you bring it at the earliest. Yes.
May it please the court. Your Lordship, I'm seeking adjournment for item number 33. This matter may be listed next week on 22nd.
I'd like to mention WPC number 484 of 2022. The matter may be listed tomorrow.
Why?
My lord, little correction is required in this case. Some
Or
necessary,
correction in order.
some necessary correction is there.
What is the matter about why you want
It
this?
is a service matter.
Service matter. Then
So even the respondent has filed affidavit, so I need some corrections from the honorable court. So
you need some corrections from this court. Where? In order, if there is a mistake, we can.
Not particularly, there's a two director. The one director is already left out, and that is unnecessary party that I want to mention before the court by when the matter comes up.
Tomorrow.
Yes, my lord. And the other, my lord, WPC number 286 of 2022. Last time, my lord was suggesting me for the lower court, so I was thinking of reply. So I would like to mention and this on that very direction of the honorable. My lord, I would like to for tomorrow, my lord.
Tomorrow.
Okay, my lord.
Give the mention. We did. Yes. Next.
Your Lordship, I would like to mention a writ petition for tomorrow for admission.
For admission.
Yes,
Readings are complete. Affidavit filed.
yes, Lordship.
Okay.
Much obliged.
Lord, may I mention the item number 34? My lord, this matter may be, I have taken consent from the respondent, my lord. This matter may be taken up on 21, my lord. 21, okay. Tuesday. Always.
Yeah, my lord. My lord, I beg to mention item number 8, my lord. Matter may be listed after 2 weeks, my lord. And I have taken consent from other party, my lord.
I'm for the respondent number 3 to 12.
3 to
12.
What about respondent number 6?
3 to 12. We have filed one affidavit in opposition and
Six,
rest.
that
is
will
6,
cover.
my
Yes, that we will cover.
All
We will
all
rely
cover.
that.
Okay. You don't want to file reply. Okay. On the prayer of the petitioner. For when?
2 weeks, my lord.
After 2 weeks.
Okay, obliged.
May I please, my lord?
Yes.
My lord, I beg to mention item number 32, my lord.
32.
Yes, my lord.
Already mentioned.
32 already.
You keep hanging.
Oh, sorry, my lord.
Pursuant to this court by order dated 7/11/2023 directed the learned counsel for the respondent counsel for respondent number 4 and 5 to produce the record of the tender evaluation committee. Full stop. The learned counsel for the respondent number 4 and 5 submits that they are filing an affidavit within a period of by end of this week.
End of this, yeah.
By Friday,
yeah.
by the end of this
Yes.
week. In that view of the matter, as parties are duly represented, let a formal notice be issued, returnable forthwith, full stop. As parties are duly represented, no fresh formal notice need be issued, full stop. The interim order passed earlier on 7/11/2023 shall continue till the next date of listing. List this matter in the admission column on when?
Friday, sir.
No, not Friday. Friday is not
When
possible.
it come, lordship, after 2 weeks, lordship.
Not after 2 weeks.
Next
Okay,
week.
tender matter.
Monday.
Monday.
Lordship.
Monday.
Okay.
Legally obliged, lordship.
Not Monday. In the meantime, you might also like to file an affidavit. Let
Lordship.
it be end of the next week.
Lordship.
Next Friday, give a date. Huh?
Oh, next
Friday.
In the meantime, the petitioner may file a reply to the affidavit
Yes.
to be filed by the to reply if such affidavit is filed.
Lordship. Legally obliged.
Yes. Yes, where is the standing also? Deputy Commissioner, is it correct that you have not allowed him to join?
No, Lordship, actually the Deputy Commissioner is out of the country, Lordship, for the last more than 10
So
days.
before whom will he join?
Lordship,
Before whom will he join?
Lordship,
If Deputy Commissioner is absent, who is taking charge of the Deputy Commissioner?
Lordship, ESC, he doesn't have any idea, Lordship, so he will be coming.
How the state is being run? If he's
Lordship,
not,
he will be reaching in 3-4 days, Lordship.
My lord,
no, that cannot be.
Lordship may see the order also, next order also. He might reach by this week.
my lord, my instruction is
Yes.
that, in fact, my lord, I have submitted my joining report on 12/10. And when he did not accept, I again sent him this reminder on 19/10, October. He was very much available there in the station and he was discharging his duty. And my instruction is that he went for foreign tour only on 3rd November. And now he has returned yesterday.
Yes.
That is my instruction.
Lordship is clearly written that he will be unlikely to return.
This is in
for
fact, Lordship,
27. Lordship, next week-
serious
So
insubordination.
this type of conduct we do not appreciate. See, you see the letter.
This is by ESC.
Inserts Deputy Commissioner. Who has written this letter?
In charge.
Inserts Deputy Commissioner.
Lordship. ESC.
So we'll remove him right now from the inserts Deputy Commissioner and ask the Chief Secretary.
Lordship,
We'll do it
ESC.
right now.
He's ESC, Lordship.
Whatsoever, if he's ESC, if he is given to run the district administration, is it his conduct?
Lordship, next page they have.
No,
annexed the-
kindly see, he is unlikely to return station before 15/11. What is unlikely? You are not aware when the deputy commissioner will come back to the district.
Lordship, I beg.
We do not appreciate it.
Lordship,
Approval is here.
I apologize on their behalf, Lordship, but then Lordship will take instruction from the deputy commissioner
It was
himself.
program is from 7th to 9th November.
Yes, but then Lordship, since it's Spain, Lordship, it takes time, Lordship.
No, whatsoever. What
Let
is
it be on-
unlikely? Officer will take a leave. He
Lordship,
has gone on official duty. He may extend his travel. We have no problem if government permits it. Government will permit for a specific date.
Lordship, I agree
And
very
the
much.
ESC,
Lordship,
who is a deputy commissioner,
I
will so
apologize.
let this person be removed. If it's so incompetent,
Lordship, I apologize on their behalf for this.
Please, this
board,
matter
Lordship,
tomorrow.
But then, Lordship, can it be on day after tomorrow, Lordship?
Day
I will
after
take
tomorrow.
proper instruction.
list this matter day after tomorrow for the instruction as directed, for furnishing of the instruction as directed by this court under its order dated 10/11/2023.
Yes, I
Please,
have already intimated, Lordship.
This is not the way how a inside deputy commissioner writes. Will be
I-
compelled to ask the chief secretary. Is it the way? He is unlikely to return to station.
Yes,
15.
Lordship.
Is it the way? He is a deputy commissioner. He has went on an official trip. Admittedly, official trip is on 9th. Okay, it may take some more time. He may get his period extended. But there is a procedure.
Lordship. I
So
agree, Lordship.
that is already decided that he will return on such and such. This is his return ticket.
Lordship.
These are the procedure to be followed. And the deputy commissioner says unlikely. And where the specific allegation is that the deputy commissioner has said that I will not allow you to join, please go to the local MLA. And this conduct, these writings of letter shows that only, nothing more. Only to delay.
No, Lordship, they are inexperienced.
No, this is not the way.
Lordship, day after tomorrow.
Day after tomorrow.
Much obliged.
Oblige.
May I plead, my lord? My lord, this matter relates to construction of 12 megawatt, the project that is called Racing Hydro.
What kind of order you are expecting today?
Yes, my lord. In fact, my lord, we are challenging the impugned site inspection reports prepared by the
So according to you, village is in X place, they have shown it to be in Y place.
White Place.
Y place, and then they have given a report, and as per the new act, the consensus of your people have not been taken.
Yes, we have filed.
As per the Conservation Act.
Yes.
Now question is, Who are you?
My lord, they are all villagers of the, where the site.
Do you want to say that these are the private land?
Yes, my lord. Private
If
land,
that is the private land, then where is the question of taking forest clearance?
yes, exactly. Without the knowledge of the village authority, without the knowledge of a Gambura of that particular village, Panchayat, that's called,
Cannot they acquire your land?
they can, but then
No,
question,
just ask me,
yes,
can't they acquire the land
they can acquire the land,
for
provided,
a private project?
yes, but then thing is
So we are
that,
issuing a notice.
but then thing is that,
We'll direct them to, if you are taking the land of these people, pay compensation to them. No compensation should be paid to any other party than the, any other party
no, my
right now.
may I just,
Not more than that. Can we stall a power project like this?
no, a question here, my lord.
You'll pass that order, you will have to give an undertaking that in the event writ petition is dismissed, you will have to compensate the whole cost of the power project.
Right.
Give an undertaking.
My lord, I will
You are
just,
saying,
oh, yeah, right. I agree. I will just
this
brief.
is the law.
No, but I'll just brief that. What happened is that,
No, we know. If your pleadings is correct, we know that. Your case is that this is X village. We are the people of this X village. This land belongs to the community of X clan
village.
and X village.
yes,
Now, the officer shown Y to be the X village.
Yes, my
Made compensation and all these things are done. Now, environmental clearances have been taken, showing it to be Y village, whereas the project is coming in the X village. This is your case.
yes, my lord, in that case, Deputy Commissioner has taken the cognizance because of the complaint of the jurisdiction, because this is coming in another village. You have shown the site of my village, whereas the project in the name of other village. Now, Deputy Commissioner has taken cognizance, saying that,
Yes,
okay,
Deputy Commissioner, then why you have remitted the matter back to the Keba?
yes, my
What
lord,
is this?
because
A public project, Deputy Commissioner says, my hands are off. You decide, Keba decide whatever.
because when there's a land dispute, my lord, if there's a land dispute, my lord, the village authority can also take the decisions whether
You
land
obtain
belongs to.
instruction.
My lord, in fact, there is a notification for acquisition at page 107.
107.
Yes, my lord. Public
Notification, we have filed objections, my
And
lord,
these-
because site which is shown to be in other village, and then Right.
So that will be decided in that case.
my lord, my lord, surprise thing is that even the district forest officer, he has done even the property assessment prior.
Your concern is compensation or your
my
concern is
concern-
the project?
No, my concern is not the compensation. My concern is that it's my village. Without my concern, that project should not come up because it's going to affect the villages. And then under the FRA,
Will provide that without, if claims to be the community land and private land, without due process of law, they should not be, neither be evicted, or they should not be disentitled from their properties without following the extent land acquisition procedures. In the meantime, not more than that. We cannot stall a project, stay in the
Yes, my lord.
project.
In fact, my lord, here.
but the
they
issue
have been
is
given
issue is that even
opportunity-
under the Environment Act also, my lord, there is governed by the EIA, that's called Environment Impact Assessment 2006. And there is two categories. A category approval has to be done by central government, and B category it has to be done by the state
In
government.
respect of,
In respect of acquisition projects, my lord.
no, in respect of,
In respect of projects or for the,
no, understand.
yes, my lord.
No objection certificate to, it's called a user agency.
Yes, ma'am.
The user agency is to be the environmental clearance is to be given under the
Yes.
Forest Conservation Act.
But there has to be correct
To
sites.
do a non-forest activity in a forest.
Yes, my lord.
Now you are saying it is your own land. How can the question of forest environment clearance is coming?
No, my lord, in fact,
Kindly come to that section.
my lord, I'll just take to this one.
The facts we have understood
Yes, my lord.
that they are making a private dam.
Yes.
This is they shown place X. It should be constructed in place X, but there all inquiries, everything has been done in respect of place Y.
No.
Now they will take the land of X on the basis of the report furnished in XY.
Yes, my
Is
lord.
not it?
Yes, my lord.
Now, second issue is that you objected to before the deputy commissioner. Deputy commissioner, I do not know, he is a collector, he is the collective, he is the authority over the land dispute. He refers the matter to the KEBA.
Kebang, my lord.
Which KEBA?
It's called
Now,
mail.
there will be two KEBAs.
It's a local, when there's a land dispute, then it has to be decided by village authority, madam. So it has been referred to the village authority, and then village authority also held a kebang, but then respondent didn't appear. And they said that, and that's how this matter is still pending.
So therefore, that is what I say. The respondents will say that we are not, that other respondents.
Yeah, other respondents.
Whose lands are being taken, they will say we do not, this KEBA is not having jurisdiction. You will say
No,
those
no, in
KEBA
fact,
will have no jurisdiction.
No, other respondent.
And what will this other respondent?
No,
do?
my lord, other respondent is the acquiring authority, my lord, the private company who was because
They are
on
not
the
acquiring
behest.
authority. They are the they have requisition that we want.
Yes,
Now-
but an owner himself is from the same other village, that's called the receiving village. The project has been named in the name of the village, and he belongs to the other village.
No, we understand, but can a read court decide all this? Number one.
Yes,
Number two, if you take a stand that this is a forest land, then environment protection, forest act, what is that act? Where that permission is required?
That FRA, my lord. FRA.
Forest regulation.
Yes, my lord.
Oh.
But then even for the land acquisition also, my lord, minimum.
Land acquisition notice is issued. You say, go there and say that you have a notice of land acquisition. You go and say that, see, this land belongs to us. Or
Yes.
you may say that this land, if does not belong to you, not belong to you.
No, we have filed the objection, and accordingly.
What is your objection to the land
Our
acquisition?
objection that was that the site which is shown to be of the racing village. is-
That is to be decided.
Yes, it's in my village, and then
So therefore will provide is an interim measure that without following due process of law, no construction be made
like that.
over the properties of the petitioner. That's
Petitioner.
all, or
Apply that-
without acquisition of land, acquiring the land.
My lord, in that event, that will stall the process, my lord.
No, suppose,
My lord,
suppose,
here,
can we take their land without paying compensation?
that it cannot be done, my lord.
If it cannot be done, do that.
My lord, that's why, my lord, if my lord comes to page one
We
fifty-five.
have issued a notice, so therefore you
Will obtain instruction, my lord.
obtain instruction.
Yes,
Hmm.
whether their claims,
You obtain the instruction because you will have to decide.
as per this impugn order at page 155 and starting ending at 157,
Hmm.
the relevant portion is at 157. After hearing both the parties, it is of my opinion,
Where?
page 157.
157.
Yes, ma'am. The claims and objections of the petitioners were decided here, madam. After hearing both the parties, it is of my opinion that there exists minor difference on intake location. Here refers trench construction site, and the drying up of water bodies do not hold merit as well. Therefore, it is
This was passed in by where?
This was
on September 6, 9, 2022.
1/9/2023.
6, 9.
Yes, my lord.
Huh?
After that, only the another order was passed in page 58 that there should be a local kebang because
Here-
there is a
here
jurisdiction
itself-
issue.
Indication was given.
Page 58, my lord. May I read, my lord? May I read page?
Did 19 in pursuant to the notice?
Yes. May I read page 58, my lord? Whereas a public hearing was held on.
Just a minute, just a minute.
Yes, ma'am. The relevant portion is the last paragraph, my lord.
This is the way projects are sanctioned. Our project.
My lord, in fact, it seems that because of the disturbances amongst the public, there is the deputy commissioner is
Now the
trying-
Zilla Parishad member is the owner of the project.
Yes, my lord. This project is, and he is from the racing village. And then assess the site.
This is how deputy commissioner decides. Is it having the authority to decide whether there will be damage to forest or not? First question is where the question has come damaging of forest. He says there will be damage of forest. The moment there is a damage of forest, you will have to have an environment clearance.
Yes,
Otherwise, whole Arunachal will go down someday.
my lord, therefore,
Yes.
a forest clearance is required. They have process for forest clearance, my lord. It is not that there will be no damage, but forest clearance under the,
Is to be from the central government.
yes, my lord. That has to be processed by the forest department. Without that, the project cannot go ahead, my lord.
If they cannot go ahead with the
Yes,
project because
They cannot go ahead.
this is not the conservation of law.
And then even if they want to have an environment clearance also, there is a
Forest or
notification which says that if the site land is located somewhere and it is shown somewhere, and then report is somewhere, report is wrong, then they cannot go ahead, my lord. But in my case, the project, the main intake is in my petitioners, the village.
There are long procedure. They will have to give
Yes.
clearance, then they will have to give a compensatory
yes, my lord.
payment. There
Yes.
must be objections to the local people.
But my lord, beginning it starts from the site inspections. In the site inspection, the site of the project itself is wrong, my lord. It's in the other village. How they can show other village to be in that which project is not coming in that his own village?
Environment Protection Act.
Forest Conservation Act also, my lord, section 2 will,
Section 2, no?
yes, my lord.
Section 2, somewhere section 2.
Forest Conservation.
Section 2.
Forest Conservation Act 1980.
70.
Section 1, section 2.
And then environment.
Section 2, which provision?
My lord,
No, this is
Forest Conservation Act
Forest Conservation Act.
19,
Okay. Sorry.
1980.
Forest Conservation Act. Very small act,
Yes, my lord.
only section 2, nothing is there.
Yes.
Is it a reserve forest? That is why I'm asking.
No, my lord, it's not reserve forest, my lord.
If it is not reserve forest, then for environment clearance is not required.
It's a community land, my lord. It's a community land, my lord.
How can you decide all these disputes? But how these projects are being cleared in the state of Arunachal Pradesh, these private power projects?
My lord,
Under what authority of law?
My lord, the EI is main governing notification, my lord, under the Environment Act 1986, section subclause 3 on subclause 3 of section 3 of the Environment Act
My lord,
1986.
section 2, subsection 2 of section 2, my lord.
I'll just check to my lord. I will just check.
Just a minute.
Any forest land.
See, we'll have to balance it. It's a project, maybe private project, but it's a project for generation of power.
Yes, ma'am.
It is having a public interest, no doubt about it. At the same time, we'll have to see the protection of the forest as well as your right. Your right, if that land can be acquired, can be protected at the later stage of this proceeding also. Suppose they are entitled to acquire your land. They will acquire earlier, but they will do proper assessment and following due process of law. That we cannot bar. But second question is that forest clearance. Forest clearance is said
prior approval of the state, central government.
Not raising any content in the law for the time being in force in state, no state government or other authority shall make except with prior approval of central any order directing.
My lord, I will just take to my lord, I will just take to 135. I have annexed some documents where it says that some application has to be filed before the concerned authority for any projects.
Okay, subclause 3 also.
Subclause 3 also.
Okay, so clearance will be required.
Clearance will be required,
Clearance will be
whether
required.
reserve or not. Subsection 2.
Now, where is your that report?
Yes, my lord. Report is in my lord, page 70. My lord.
Survey report.
Page 70, my lord.
178.
70.
70.
Yes, my lord. May I read the 70, my lord? Annexure 2. Annexure to Mary, my lord. Proposal for diversion of forest land for non-forestry proposed was received from MS such and such for development of Rising hydroelectric project 12 megawatt located at Rising village, my lord, in the Sagali forest division, Papumpara district. Page 70, my lord.
Just a minute, just a minute. Procedure was given details.
Yes, may I just read the first from the beginning, my lord, where it is mentioned Rising. May I just read, my lord. Proposal for diversion of forest land for non-forestry purpose was received from MS such and such private limited for development of Rising hydropower project 12 megawatt located at Rising, my lord. Whereas this project, the main intake is not located in the Rising village. It is in the.
Just a minute, just a minute.
Yes, my lord.
Who is this officer who has given site inspection report?
He is a divisional forest officer, my lord. My lord, we will see in page 72, bottom right, divisional forest officer, Sagali Forest Division. And other thing is that this DFO can do only inspection, but he cannot decide the site of the place. The problem started with the site of the place, which they have mentioned Rising, whereas the project is not coming in the Rising village, it is coming in the Sango village. But then as per the DFO's report, it is mentioned Rising village. So they have disputed before Deputy Commissioner. And even they have written letter to the Chief Secretaries and various authorities saying that the site which is shown as a Rising village is not in Rising village, it is in a Sango village, comes under the Pape Panchayats.
Yes, you are arguing somewhere else. Come prepared with the law. Yes, Deputy, this is under process. This is premature.
But the deputy commissioner has passed the order which says that there should be a village decision.
See,
Then,
are you aware of Rule 6 of the Forest Conservation Rules?
but then the name of the place has to be correct, my lord. Forest division cannot mislead the authority to get the environment clearance, my lord.
This is not the way. Way is that that's why I said I brought the book. Because there is certain procedure laid down. How it to proceed, even fixing the timeline. Go to the rules. Forest Conservation Rules 2003. So in Arunachal, there will be no, these are the Gaon Buras and Gram Sabhas are not there.
No, we have Gamuras, my lord.
Gram Sabha.
Gram Sabhas
It's not
is a village authorities are there, my lord.
Huh?
Village authority.
Whatsoever. So two parallel proceedings is to go on. One is the forest department, other is the forest divisional forest officer, other is the deputy commissioner. Deputy commissioner is the nodal officer. So deputy commissioner is to give a finding, go through Rule 6 and satisfy this court.
My lord, I'll just take to my lord 150 of some notifications are there. If there is something wrong in the site of the project, then this environment clearance also cannot be done, my lord. 150, my lord, I'll just take to 150.
We understand that. Kindly come to Annexure 7. Where is the village zone?
Yes, my lord. My lord, subsequent, my lord, page after hearing, my lord, is 157. After 157, the deputy commissioner has order for the village authority to decide the jurisdictions, my lord. Environment clearance is no issue, my lord. But the question here, the site which is shown as wrong, that has to be decided. That is the issue.
No. Where is the site given in the?
Yes, my lord. My lord, second line, my lord, third line, my lord. Page 70, third line. Third line, my lord. May I read, my lord? Proposal for diversion of the forest land for non-forestry proposed was, and then schedule of the land, proposal was received from the MS such and such private company for development of Rising hydropower electric project located at Rising village, my lord.
Located at?
Rising village.
Where is that?
It's in the third line.
Rising village. And what is your village?
My grievance is that this village, this project is not in a Rising village, it is in Sango village.
So I'll say that if it is a Sango village, this Rising village cannot give up this Rising village report.
Yes.
On the basis of Rising village below, no construction can be done.
Yes, my lord, that is the only issue, my lord.
Yes.
My lord, if his grievance is only the name of the village is incorrect.
It's a location, my lord. Name, not only name of the location which they have shown.
My lord may dispose of with an observation to determine.
No, this method we may dispose of, then deputy commissioners, I have not having faith. See, if this is the situation, why the villagers will come? First of all, if their lands are not touched. This is basic fundamental. If you do not touch their land. If you want to have a construction is Rising village, if you are proceeding with the site inspection report, you proceed with that. But if their lands are not under this part, so do not do that.
Yes.
This is their grievance.
My lord,
Yes, yes.
that will be clear from the land acquisition. This because here it seems the land
is in the Rising village.
Yes, my lord. If my lord comes to the schedule.
So therefore, they have filed an objection till the final objections in the land acquisition procedure are not decided. That has been decided.
Decided.
But no, land acquisition has not started yet. Land acquisition has not yet.
No, there is a notice.
Yes, we have filed objection, my lord.
So any decision taken on there?
Yes,
but after that, my lord, deputy commissioner has decided to send the matter to the local Kebang, my lord.
No, before that, the decision is taken in the land acquisition proceeding.
No.
That order you have shown.
Yes, order which I have shown, my lord. It is, my lord, in page one
No,
five
we have
seven.
shown that order.
157.
Deputy Commissioner's order.
Yes,
my lord.
ma'am. 157, my
Where
lord.
is that?
At
155.
157, my lord.
15, it starts from 155, my lord.
Just relevant portion, may I read, my lord?
It says public notice is of 24 July 2023, my lord, at 107. That is the public notice for acquisition.
May I read 157, my lord? After the hearing of both the parties, it is of my opinion that there are.
Now, this writ court is a court.
Yes, my lord.
For suppose you want to set aside disorder.
No,
One nine.
not this order, my lord.
One,
My
19 you are happy.
issue is my
19 you are happy. Tell us.
my lord, my issue is your lordship.
No, your issue will come only. See, there are certain fundamental things. You cannot avoid answering those questions. There was a land acquisition proceeding. It relates to Raging Village.
Yes,
You
my lord.
say that the project is being constructed in our village, not in Raging
Raging
Village.
Village. That's the only
Not-
issue, my lord.
Not Raging Village.
Not village.
Now, you file objection in the land acquisition process.
We have filed objection, my
You
lord.
have filed objection.
Yes, my lord.
That is decided. By saying that there is a small ambiguity.
No, not decided, my lord. They have referred back to the village
No, no,
authority.
no.
I will just take to that, my lord.
You are not agreed by 19/2023.
I will just take, my lord.
No, just take.
Which is mentioned here, my lord. It is,
See, after hearing both parties, it
Yes.
is of my opinion that there exists minor difference on intake location.
yes, my lord.
Okay.
Main is intact.
Hmm.
And then refer a trench construction site and the drying up water body does not hold merits of rate. Therefore, it is expedient to order to hold a sabha, my lord. Sabha means a local kebang, my lord. In the Nishi, this is called a NYEL, nail, or MEL, well. Between the Pepe and the Loporian panchayats and other to decide the location jurisdiction rights and also decide the sharing of the benefit before and after the project in form of a memorandum of understanding within 14 days from the date of the order and submit to the undersigned for the convenience of public, and decision may be submitted to the circle officer reporting for further submission. If the difference is not
Okay,
sorted
you
out,
decide. Let the deputy
They-
commissioner decide. They let this keba or something like that decide it. Nobody
yes,
agree by
yes, that's
order.
what, my lord. It is still pending, my lord.
May I, my lord?
And page 158, my lord, may
My
I
lord,
like to see.
first let the petitioner be specific what he wants.
That is what I am asking.
Whether he wants
What is
the
your prayer in
project.
the writ petition?
No, we don't, petitioner doesn't want the project should be started misleading the name of the project, because project is not happening in my village, is happening in my village, but then as per the official order, it is in the Racing village. Now, in this situation, land acquisition may not happen in favor of petitioner, that is one. And other is that villagers,
Can they take your land without acquisition?
they cannot take.
They cannot take.
They cannot
Difference
take.
here.
So we have objected, my lord. They have issued a
So that is to
notification.
be determined by what is your grievance? Tell us.
My
Let us see
grievance
your-
is that,
Let us see your prayer.
yes, my lord. Let it be decided by the local kebang, which is been decided by deputy commissioner, my lord. Because that jurisdiction dispute is still remain with the deputy commissioner. Deputy commissioner directed to the local authority to decide, and then local authority, they have not yet decided. I will just take to, my lord, page 60, my lord. Page 60 was for the village kebang.
No. When this matter was sent to the deputy commissioner,
My lord, may I please to see page 158, my lord. 158, last paragraph, may I read? 158, may I read, my lord? Circle officer reporting is hereby directed to arrange mail, my lord. Mail is a local kebang, my lord. Immediately.
Now, why have you come here? 14 September, the decision is taken. 14
my lord,
September, it was sent
yes. And
to the circle officer. You want the circle officer to do it overnight and settle the dispute?
No, my lord. It was sent to the local authority, my lord. I'll just take to 160, my lord. 160 is the local authority decision, my lord. 160, my lord. 160 is the attendance of this mail. Mail is a local kebab. It was decided, and in this one type copy is 161. My lord, just may read that one. 161 is the local kebang. May I read?
Now,
That
what
was
is your grievance? Keba is not being held or
Yes.
no decision has been taken.
So, my lord, my grievance is that the site, as per the
No,
site.
no, forget that we cannot decide.
Yes, my lord.
That we cannot decide.
But till the village decision is not come out to decide the jurisdiction of the site, no such activity.
Why are you apprehending that they are taking some action?
Because as per the site report also, it is shown as a recent village. My lord.
Oh my goodness,
have-
why are you apprehending that they will, no, deputy commissioner has passed an order saying that held the kebab for the determination of the area and who falls under whom and what should be the benefit.
But now the activities has been started, my lord. That's what, without decision of the village authority, activities also happening in that area. That's what, and then one of the Gambras also arrested because he visited the site saying that this is my village. Why you are doing some activities there? Then they have arrested even Gambra also. That is happening because still jurisdiction dispute is still there, my lord.
See, that is still continuing. We'll say that the authorities shall be at liberty to take a decision in terms of the order dated 14th of September 2023 through the local mail. Through the local mail, till then they should not be evicted.
Yes, that much, my lord.
Till then, they should not be evicted.
They should not be evicted
Yes.
from their land. Okay. Third, Mr. Mo, learned counsel and so and so and so. The present writ petition is filed with the following prayers. Okay, prayer to quote unquote. According to the petitioner, petitioner, land acquisition notice, a notice for acquisition of land. Where is that notice? 157.
107.
107. Was issued under section 10 of Balipara/Tirap/Sadia Frontier Track Zoomland Regulation 1947 for acquisition of land for construction of racing RESSING hydroelectrical project within bracket 12 megawatt by Messrs. Gekam Power Private Limited under Leporiang Circle, Papumpare district. The location of the land was stated to be racing under Leporiang Circle. And a specific boundary has also been given in the said land acquisition process. It is the case of the petitioner that they have filed objection to such public notice inasmuch as it is their case that though it is said that the constructions are to be carried out in raising village, however, in fact, the survey has been done in respect of the villages and lands belonging to the petitioner and their communities. Full stop.
Survey has not been done, my lord.
No.
The site inspection.
Site inspection, not survey. Site inspection has been done in respect of residence.
That is Lungruk village.
Okay. On the basis of such objection, the Deputy Commissioner passed an order on 1/9/2023, whereby the issue regarding location and jurisdiction rights was referred to the Sabha within bracket Nil in Nisi between Pape and Leporing Panchayats and others Full stop. It was further directed to submit such reports. It was further directed to the circle officer Leporiang to submit such report. Subsequent to this, certain procedures were initiated by the circle officer Leporiang. Full stop. The petitioner's apprehension is that while the matter was pending,
Village Panchayat, village council also held, but then other side, they didn't come.
matter is pending.
Yes,
matter
matter.
is pending, and some meetings were also held. However, during final determination could be made, the petitioners are sought to be evicted by starting construction of the power project, in as much as the acquisition land has not been acquired till date. Full stop. That being the position, this court, in the backdrop of limited grievance of the petitioner, as quoted herein above, is of the view that this matter can be disposed of at the motion stage itself, directing the circle officer Leporiang to complete the what is called
Nail, MEL.
nail
Nail arrow mail.
complete the nail and submit the report the deputy commissioner, and the deputy commissioner shall thereafter take a proper decision in this regard. Full stop. Till such decision, final decision is made, it is provided that the petitioner shall not be evicted from their land without due acquisition of.
Or no activities, my lord.
Huh?
Or no activities.
No, my lord. Shall not be evicted from their land, my lord, if there is any structures of the petitioners.
No, not structure is not
My
required.
lord,
Land is enough. my lord.
Lord,
Land is the issue. here. No, we have not
their
disputed a structure.
problem is that their structures.
Their land, not their properties,
Yes, my lord.
which include the land and all, huh? So their
Yes,
properties
properties.
shall not be taken away by the state for the purpose of the project without following due process of law. In as much as it is the case of the petitioner that in the land acquisition notice, their lands are not included.
Yes.
Your land is not included, rather in the
My lord, land acquisition process is not done, my lord. So it may be limited.
notice is a process, is not it?
Yes, my lord. It may be limited to mail, my lord.
No, my lord.
I will pray that it may be
They are
limited
saying-
to, because mail will decide
No,
who
no,
is the
there
lane
are
owner.
some issues. Suppose
Yes,
we take it, however, parting with the record, it is
Because you-
provided that this court has not judicially reviewed the order dated 1/9/2023 on its own merit. Tomorrow, somebody may come and say that this forest clearance is bad.
Yes.
Can that forest clearance be like this? Deputy Commissioner will say,
Yes.
decide that there is no damage to the forest because the owner of the project has made a submission. We are not going there
Yes.
to that. But this is the way, if you are doing damage to yourself.
Okay,
Nobody can save you
but the problem is
from
that,
from going down.
but problem is that,
Now see the Kedarnath, Badrinath, they are going down.
my lord, problem is that misleading it has misleading in
Everybody
the
is
side reports only.
interested in the land. Take my land, do whatever you like. Cut the trees, remove the hills, no issue. Give me the money. That's all. You have no grievance regarding that river will be dried up.
No, that is my grievance in this.
But you have not challenged it 1/9.
No, that is also a grievance in my petition.
Where is your challenge to that 1/9? Why have you not challenged this? We would have stayed this. Can it be decided like this?
No,
Environment
no,
clearance.
1/9 also, my lord, it is said that jurisdiction goes, means the project cannot come in my place, my lord. Because racing
You are
is
not
some other
getting
place.
my point.
Because racing
You
is
are
some-
not getting my point. Anyway, God help you, people.
In fact, we don't want project also. That's as per petitioners.
But you are not aggrieved. The deputy commissioner decides that oh, nothing, there will be no river dried up as if he is an expert.
Yes,
There
but
will
that
be
is
no
there.
dried up, there will be no forest will be damaged, but this will not hamper. These have been taken decision by the deputy commissioner on the basis of whose submission?
That is there.
On the submission of the owner of the project.
Yes, my lord.
What is the others objection? Nothing is there.
That is- that-
except writing.
that is
But
there.
you are not challenging this. Can you set aside this without your being challenged? That's why you have written it last paragraph. However, this has not been judicially reviewed.
No, in fact, in our petition,
We
my lord,
understand, we understand.
we are also challenging
We
that.
understand many things. Who are interested with whom.
Yes. We are not interested in only land, my lord. In this case, especially in the.
That shows your action shows. You have not even challenged that there will be no damage. And that has been decided by the deputy commissioner. Can deputy commissioner decide? The circle of divisional forest officer will have to seek for objection. Then he will have to send it to the Ministry of Forest.
Yes.
That rules you have not even read, rule 6.
But environment, my lord.
Okay, next case.
Oblige.
You are enjoying a stay.
Yes, my lord, but
Enjoy.
May I, my lord?
this because of my learned friend, he's been seeking time.
My lord, I am paying some more time, my lord, to file epidemic, my lord, counter epidemic.
What is your case?
My case, my lord, was I had put.
You have been issued a land permission.
Yes.
Allotted. Subsequently, it was cancelled. What is the procedure for cancellation?
And now, my lord, that authority who issued the impugn communication, he has now said after an inquiry that everything is fine. Body
Who are
of the
you?
court.
My lord,
Against that, he wants to file something.
we are the occupant of that, my lord, occupant of the land, my lord, power department, my lord. We are alleging, my lord, this land belong to us, my lord, that has been
You
encroached
have
by.
seen all evictions are of power department or what? All lands
They don't
belong
have
to
even
power
an
department.
allotment also.
Huh?
They don't even have an allotment order in their favor.
If allotment is done, go for cancellation of that.
That we have gone for the cancellation, my lord, and on our complaint, my lord, the impugn order was issued.
But only on your complaint cannot be. There must be a proof that this land belongs to us.
And now, in fact, this authority, the same person, my lord, he conducted an inquiry subsequent to this impugn.
And submitted report.
Yes, he says now everything is fine.
Now see,
It can be
court will
restored.
decide that it belongs to him.
My lord, that
Or
was
your conduct.
why, my lord,
And will decide it, then your all roads ends.
that's why, my lord, we are praying, my lord, some time to file affidavit again, affidavit filed by the that person, my lord. I have received the instruction, my lord, and also
They have not put to challenge the report also.
maybe, my lord.
You let them say, file it by affidavit, then you reply. The learned counsel for the respondent number 7.
My lord.
7
My lord.
submits that the respondent number who has taken the stand in your favor.
1, 2,
Respondent
3, 1,
Huh?
2, and 3, my lord.
Respondent number 1, 2, and 3 has taken a stand on affidavit which is detrimental
My lord.
to the interest of the respondent number 7.
Right.
Accordingly, he prays that he may be granted some time to file a reply to such affidavit.
My lord,
Subject to maintainability of such reply, comma,
Already, my lord,
subject to maintainability of such reply in the present proceeding, comma, the petitioner is permitted to file such a reply.
respondent, my lord.
Respondent number 7 is permitted to file a reply affidavit to the affidavit in opposition filed by the respondent number 2. Last of the subject to maintainability of such maintainability and acceptance of such an affidavit, a reply affidavit.
My lord, on 7/8/2023, I was already granted that liberty by reason of
Interim order passed earlier cell. You have given liberty to file, but whether that can be
My lord, my-
accepted
that
is
is true.
always subject to, even if I do not write.
Yes, true.
Uh,
Obviously.
List after
3 weeks, my lord.
3 weeks.
Okay.
My lord, item 10 to 20 is termination. with,
APSC,
yes,
APPSC.
my lord.
It
Termination.
will take some time. Yes, what do you say? Should we admit this and fix for hearing? Or you want to have it in admission stage? Admission stage. But it will require hearing because these issues are in the Assam also.
Yes, my lord.
There are some judgments in those cases. What happened to the still pending? Appeal is still pending.
Still pending.
Similar issue.
Similar issue.
Here there is a provision of extension. But there is no extension order. In your case, there is no provision. According to the petitioners, there is no provision of extension. Therefore, according to it's a deem. Moment its deem is accepted, then it will be requirement of 311 required to be followed.
In some cases, but not all,
Not
my
all.
lord. All those deem extension, all those who have completed probation, my lord, their departmental inquiries are going on, my lord.
And okay, they have not been removed.
No,
Proceeding is going on.
Yes, my lord.
Okay. Okay, so when tell us. It may not be possible for me to complete the hearing and pass as well.
Okay. Let it be. Let it be, my lord, then on 21, my lord.
21st,
21st.
Tanging,
Oh, no, but
14,
28. 23rd.
21st or 22nd.
I'll not be available.
21st. Tell us a convenient date for that
After 3 weeks.
after
3 weeks.
there is no
But-
stay.
My lord, yes, in some, there are, in 1-2 matters, there are stay. But anyways,
Okay.
Some of the petitioners got interim, some are not getting interim. So,
Okay, give a date, specific date.
4th December.
4th,
Yes, madam.
4th of December.
7.
My lord, can it be not in Monday, from the
12th.
5th. From 5th.
5th.
5th of December, because it
5th
will
December.
continue ultimately.
I'll be out of the station.
12.
12 o'clock.
No, no, let it be 6th.
12 will be there will be vacation mode.
Yes, my lord, 6th.
6th.
Yeah.
Yes, but in 6th.
6th.
We start on 5th. You will be available on 6th.
That can be done.
Item now interim in which cases?
Item number 16.
Give the list. Where are the interim orders?
I think. And item number 11 also in my case also.
Interim is there. Okay, give a list of the interim orders. Where interim or not silent, huh? Interim orders are there. Interim will be continued.
16. Yours is 16. All right.
Mayor, my lord.
Yes.
Well, on the last occasion also, they have short time, my lord, because by stating that they have received the instruction, my lord, till that they have not filed their affidavit.
No, we have not received, your lordship.
Vigilance clearance.
Yes, my lord.
Is it required
Not, my lord.
under
we have-
the rule?
Yes, my lord, no.
We need some time, your lordship. We'll
Let's
file our
take small
affidavit.
talk, my lord.
We'll file our
I'm only
affidavit.
praying
your
for
lordship.
consideration of my promotion, my lord.
No. If for promotion, generally in promotion cases, so promotion vigilance clearance is required
No, my lord.
under the rule.
No,
If it is required, it is required.
it is not required in the rules.
It's not required in the rule.
Yes, my lord.
Generally, it's required. There may be some office notification
Yes, sir.
where it
As
says,
per recruitment rule, no, my lord.
but there must be some notification.
Notification is there, my lord. Yes, my lord.
Then,
Now, whether the notification can overrule, my lord.
no, it's not a case of overrule. It's a case of supplementing.
my lord.
not supplanting. There's a difference.
My lord.
They may have that will need required is.
But I have specifically made my statement that there is no pending criminal case against me, my lord.
But
No
there
department
is,
of
a, there is no objection has not been issued.
Oh, NOC has been issued, my lord, on half-hearted manner, my lord. Page 102, my lord. The
Yes,
NOC,
let
my
them
lord.
file an affidavit. Please file an
Yes.
affidavit
Yes,
because
Your
he is also either he gets or he'll not get. That's all.
My lord,
You
I have
take a
joined
stand
Yes.
that
in the year
this is
19
required
Yes.
and this is not the vigilance.
Gotcha.
This cannot be treated as so and so. We'll decide.
My lord.
Okay.
3 weeks, Your Lordship. We will file.
3 weeks too much.
My lord.
2 weeks, Your Lordship.
2 weeks.
My lord.
2 weeks.
Oblige, Your Lordship.
Obliged.
On the prayer of respondent number,
All the respondents, Your
all
Lordship.
the respondents.
Obliged.
Oblige.
May I plead, my lord? My lord, this matter relates to suspension of Arunachal Commission members of Arunachal Pradesh Public Service Commission, my lord.
Will they examine?
My lord, he is against that one member who did not resign, my lord.
Okay, okay.
And that has been her this
No, we have just separated it
Yes,
from
sir.
that case.
that was earlier. The existing members, there were 4.
Some reason he has not resigned. The
She did not
suspension,
resign,
she is
and-
resigned and she says that under 317, that suspension was not made as per subsection, sub article 2
Yes.
of 317. Is that it?
Yes.
Is it? We'll hear it some other day.
Yes, my lord. Otherwise, proceedings are going on before the Supreme Court.
Okay,
Reference has been made
Reference-
by the
reference.
president
okay.
already. After the reference by the president, then by virtue of 317, governor has suspended, my lord. Now he is against the
Okay,
suspension.
as agreed to by the learned council for the parties, list this matter after 4 weeks. Let us see. Yes, 23, 24, 25 and 28.
Yes, my lord.
Affidavit.
My lord, here, I need,
Why you need time? Be bold like the other case.
my lord, I sought for Paravaj's comment from the department, my lord, yet to receive, my lord. So I may
Okay.
given 3 weeks time, my lord.
3 weeks time.
Item
23, 24,
4,
25
25.
and 28.
Yes, my lord, it's
Yes.
connected. My lord. And my lord, my name may be directed to reflect, my lord. T Tagum, Taba Tagum, my lord.
Tabatarum.
Yes, as a standing counsel.
Standing council. Now this is not Jammu. Jammu is
Jamo, he's also, but I have been assigned to this.
specifically.
Yes.
Okay, okay. Not Jammu. This is you are Mr.
Taba Tagum,
Tabatarum. Titarum. Huh?
T Tagum.
Further, respondent, the education department, phase 4 is granted. Further,
3 weeks time. My lord.
3 weeks time to file a video.
obliged, my lord.
Deeply obliged.
Yes, who files this IA?
Yeah. My lord,
You will
I-
file a reply?
no, my lord, IA may be treated as affidavit in opposition.
Okay,
So, let him argue, my lord.
okay.
Why-
There are two judgments. There are 2 judgments by division bench. This DDO and head principal
Yes.
by the division bench, authored by me. One is tested in Supreme Court, other I do not. know.
My lord, I have distinguished fact from that, my lord.
Okay,
Suggestion, my lord. Because my lord,
okay, not today,
no problem.
not today. He's enjoying his stay, let him enjoy till the next week. Too many works. Yeah, I'll have to dictate with judgments also.
Correct, correct. Well,
Monday.
When?
Monday, 20. Yes, my lord, 20. Because,
You are relying on, I think, to division bench judgment.
yeah, I am aware.
Huh?
I am on the pregnant
Let me,
transfer.
let me not be part of this litigation. Let other thing. I authored in the division bench, so let me not.
Yes, my, that's true, my lord. That's
I'll
guideline.
have a view, no?
Yes, my lord.
Already I have gone through the record. I have specific findings, so it's not better not to.
That in Assam, PSC case also, the
Mm.
Dole case.
Mm.
Lordship was there as a counsel. And in fact, all the stalwarts were there. So that a previous case, and I was thinking.
That's why I know these facts and judgment. That's why it should not be.
Correct, correct.
Uh,
Consented to by the parties.
Mr. Tara Learned Counsel submits that his IA may be
Treated as
treated as
affidavit.
affidavit for deciding the matter. However, deciding the matter. At the same time, he expresses some urgencies in the matter as there is an interim order operating. First of, accordingly, as agreed to by the board, the Learned Counsel for the parties, list this matter
28,
huh?
20,
20
20,
20 in the admission column
yes,
along with the IA.
2011,
In the admission column along with
yeah,
the
November.
Interim.
interim order pass shall continue till then.
Acknowledgement.
Yeah, my lord, please. My lord, as per the last order, I have taken a step and service is still await.
The notice to the respondent number 5,
Yeah, 4 and 5.
4 and 5
Yeah.
was issued only on 13/10/2023.
Mm.
First of, await service report and matter be listed after 2 weeks.
Okay, 2 weeks.
After 2 weeks,
Your Lordship, no extra copy has served to us.
okay, after 2 weeks. After 4 weeks, with a service report. Full stop. The petitioner is to serve the extra copies of the writ petition upon the Learned Counsel representing respondent numbers
2 and 3, 1, 2 and 3.
1, 2, and 3 within a period of 3 days from today. Thereafter, the respondent number 1, 2, 3 may file their affidavit in opposition, if so advised.
But this matter, I moved in vacation branch in Guwahati. The stay was also taken there.
But yes, that we can understand.
Yes.
Learned, though office note dated 14/11/2023 reflects that no steps has been taken by the Learned Counsel for the petitioner. However, Mr. Tara submits that as this writ petition was moved in the principal seat at Guwahati, the steps were also taken therein. Be that as it may, he prays that he may be, however, he prays that he may be granted 2 weeks time to take fresh steps. May be granted 10 days time to take fresh
2
steps.
weeks.
2 weeks time.
2 weeks.
Because you are enjoying in interim order, fresh steps. Prayer is allowed. Steps be taken within a period of 10 days. Within a period of 10 days. Interim order passed earlier shall continue.
List after 3 weeks.
Full stop. List after 3 weeks.
3 weeks. Great comment.
Then same in item number 31 also.
Yes.
31 also.
31.
Take steps.
Yes, my lord.
Interim same. But this not your name is
S. Chetri, my lord.
Huh?
Sumit Chetri.
Sumit Petri.
Yes.
No, Lordship. Here in the case, my lord, I was appointed in a substantial post as LDC, still LDC, and appointment letter is, my lord, it is in page.
What is their stand?
Now, my stand is that.
No, what is their stand? Respondent stands.
Respondent stand is that there is no post, no vacant post. But in affidavit in reply, I have filed
Hmm.
and clearly stated that there is
You
a
are now working as LDC.
LDC.
Now you want to be promoted to the
No, regularization.
regularized.
Regularization. And here in my appointment order is page 13.
Now you are how can we direct for regularization?
Page 14 is my appointment order. Appointment page page 14. Approval is hereby accorded to the engagement of Sri Kagem Lego, son of Sri Akek Lego, village I, PO Mabo district Ichiam of Arunachal Pradesh as contingency LDC still on monthly wage of such and such rupees
But
9,900.
can we direct for regularization in view of Uma Devi and on subsequent judgments?
So for regularization is law. Law is very clear, lawsuit. He cannot be regularized, lawsuit. And my senior, even the RR doesn't support that lawsuit. My senior, who was my senior, he was. Uma Devi makes very clear lawsuit. Their case was regularized. And how long I'll continue as in the same post? Now I have crossed 23 years. In same
That
post.
understand, but in Uma Devi it specifically stated that do not pass any order of regularization. Number one, regularization is permitted only when against a sanctioned post appointed through appointment in a procedure akin to a regular selection procedure. You are engaged in a daily work basis. Can we pass a judgment saying that regularized because of his long service? That is not permissible in Uma Devi. And other all other subsequent judgments. Let us take it matter after a week. List this matter as agreed to by the learned counsel for the parties. List this matter after a week. Specifically said, don't issue any writ for regularization. Supreme Court in Uma Devi. So no way out except their mercy.
In that case, my lord, pay penalty can be invoked.
That
is not prayed here, lord. In the prayer. That's not the prayer, lord.
That of course they can give you.
Yeah, that is
That is a mandate of law also. Yes, Mr. Tara.
Well, caveat maybe
Okay.
this shirt.
Caveat stands discharged.
Where is this?
Mr. T.T. Tara appears for the respondent number test caveator. Caveat stands discharged. Now tell us what is this case?
May I please, Lordship? This petition is filed against the Lordship impute transparent posting order modification.
Where is that order?
Page number 35, annexure 10. As per the 7th November 2023, this transfer and posting order has been modified and I have been transferred out from one station to another.
Impugn order is at page 35.
35.
Which is your name?
My name is Tagang Jerang, serial number 2.
Tagang Jerang.
Yes. Serial number 2. I would like to take your lordship back to the this transparent posting order.
So you were transferred from
Yes.
ICDAO.
Tagang Jerang is DAO under transfer and as IC DTO Pasigat. FTC Pasigat.
Now tell me your earlier transfer order. So
kindly, I would like to take your lordship to page number 26, annexure number 3. This is the group of officers. This is the group of officers whose transfer is due after expiry of 2 years of services in the particular station. All those officers has been transferred and posted to from one station to another. Accordingly, my serial number is page number page number 27, serial number 15. 15. This is Tagang Jerang. In charge DAO Yingkyong Upper Siang
as insert DAO District Agriculture Officer Boleng, Siang District.
Where is that Tate Jammu?
This Tate Jammu Bais. Tate Jammu is here. Tate Jammu is serial number 20. Kindly see the serial number 20, page number 27. Tate Jammu
This is the Mr. Tara's client, Tate Jammu.
Yes, Tate Jammu client. Tate Jammu is the insert DA Boleng, where I have been posted now. This insert DTO Pasigar. In my place, Tate Jammu has been retained where I have joined, and Tate Jammu has, I have been posted again.
When this order was issued 3rd of October 23.
Yes, 3rd October 2023. And accordingly, as per this transparent posting order, Lordship, page number 28, Annexure 4, I have been released from the establishment of 28, 28, Annexure 4. I have been released from the Yingkyong by the Deputy Commissioner concerned, who is the nodal officer there, so as to enable me to join in new place of posting at Boleng. So in the page number 29, again Annexure 5, on dated 12 October 2023, I have joined at my new place of posting at Boleng. I have already joined. As per in compliance of the group of officer transparent posting order.
This is dated 12/10.
Yes, 12/10. And after joining on 12/10, I took expertise as per the relevant rule on 27 October 2023. Mr. Jammu was lingering giving charges to me, although I have joined as per this in compliance of the transparent posting order. So what he did, as per this page number 33, Annexure 8, my salary also has been released from the Boleng establishment as a DAO of the month of October, since I have joined here. So after joining my services at Boleng as per this transparent posting order, this private respondent number 5, this local MLA of the area, Ojing Tasing. Here's page number 34, Annexure 9, kindly see. As per this retention note, a UO note, what he writes to the Honorable Mantri, Honorable Minister concerned, saying that I am relevant portion, I am reading the Lordship, I am reading the relevant portion.
Page 34.
Page 34, Annexure 9. In this connection, I am reading the only relevant question. This is with regard to Tate Jammu, this private respondent. It is stated he is a sincere and efficient officer, admired and respected by the public of the Siang district for his work. I, being the local ML of the 35 Assembly constituency, have received immense requests and pressure from the public. There is a public pressure because that pressure has been built up by
Yes, Tara, you are staying it and call for the record and we'll decide.
My lord,
How can I change my decision as in support of you? Hard. The learned.
Before that, may I place on record, my lord, the petitioner, my lord, has been released on 13 November 2023.
Oh, let him release. We'll stay that. What? How far it will go in this state like this? Huh? Same. Hard. Mr. Learned Counsel for the petitioner. Also hard. Mr.
L per me, my lord, for respondent number 2 and 3.
For respondent number
2 and 3, madam.
2 and 3, and madam 1 and 3, and Mr. Tara for
private respondent
number 4. Okay, we'll pass this order in the chamber. We're staying it, and we'll stay there also.
my lord,
Sorted. We'll produce the record.
Obviously.
Yes, given the record, but we'll produce the record. We'll see the original. And if so advised, then you may file affidavit in the meantime.
Yes.
We'll give a date, next week.
20.
Next week or which date? Give a date.
20.
Huh?
20.
Today is 15th.
Give a date because you will definitely file an affidavit.
I will not file. I'll give the law point.
Yes.
Long point.
Sorted maybe.
I believe, my lord, a record will suffice, my lord.
We'll
20 Monday.
We'll submit the record regarding the subsequent transfer orders.
Monday.
The record pertaining to this transfer.
Till such time, stay order.
Stay. No doubt about this.
Yes.
Obviously.
We'll pass this order in the court. Stay, yes, inform the department that they will not act upon this
My lord.
subsequent. Okay, so we may online uploading the order may be difficult today, but inform.
Obviously.
We'll record it that standing that you will inform the respondents that we have stayed it
Well,
today itself.
My lord.